Good afternoon. This public hearing, I would like, and all the
Caso Gamboa, García y otros versus Perú. Corresponde ahora que la representación de las tres
now the presentations of the alleged victims, the state's representation. It's not enough time for the representative of the alleged victim of the state to present their final oral arguments on the preliminary objections and possible merits, reparations, and costs. In this case, the representative of the Inter-American Commission to present their final observations. We'll give the floor to the representation of the alleged victims to present their final oral arguments. Request that you indicate to the court the name of the person who will take the floor. Thank you very much. I'd like to the Inter-American Court of Human Rights to we're going to give our arguments. I'll give the floor to Christian, then to give the floor to my colleague Angela Lilon to develop this. Principally, we're going to talk about the preliminary objectives presented by the Peruvian state, and taking into account that these were responded to by in April of 2024. We will not refer to them at this point. We request to the court to consider the arguments presented in that communication. Regarding to the context, in the period of 1980 to 2000, Peru had an internal conflict that affected a large part of its territory. And in the conciliation of Peru, the conflict was started by Sendero Luminoso that declared themselves in war against the state. Then we had the Tucamaru revolutionary movement was added that started their armed conflicts in 1984 approximately. And then we had the violent and more prolonged violent episode in the entire history of the Republic. Within the context of the internal armed conflict, the practice of methods such as torture and other cruel practices became an instrument of the subversive groups. And women were affected by the violence compared to men. And part of the context of the institutionalization, there was a practice of sexual violence against women, and violence sexual as a particular way of torture was a method that was frequently used. We don't have separated victims, a number of victims sexual violence against the fight of terrorism. However, the Commission on the Truth, that the complaints of sexual violence, 83% were done by agents of the state. These were characterized in the first place. A lot of the cases were not denounced from that the victims of sexual violence that affected them to put the facts to the authorities. They were afraid of being victimized and stigmatized. On the other hand, women did not let women present the complaints. They didn't. So it became more difficult to obtain justice from women who were victims of sexual violence. And this way, in this case, this Honorable Inter-American Court can develop more its jurisprudence within the framework of violence, carrying out intersectional analysis in cases that have to do with indigenous women and minors, and to extend the development of that jurisprudence will allow to create international applicable standards to cases like this. We're currently within the framework of violence in which abuse and rapes were done to peasant women. And in women, they didn't have justice, but they were criminally persecuted. Within the events and as background, the case under the concept, we present the case of Georgina Gamboa. She was born in February 15, 1964 in Parjo, in Cargomán, Ayacucho. Cristina worked with her parents, and as you see that, and the December 24, 1980, Sendero Luminoso went into the areas in Caso and they grabbed the owners. Afterwards, the owners of the farms, those who died, were affected by this greatly. And in Georgina, we see in December 25th, 1980, the authorities went to the homes to use them to testify on what happened. And that day, Georgina, with her mother, with her sister, they presented themselves voluntarily to the police. And however, the police detained them, and they were detained until the father of the victim, Máximo Gamboa Castillo, was able to get there. Then the father went to the police, and they liberated Georgina because the parents pleaded to them, and she was the eldest of the siblings. Then Georgina went back to her home and took care of her other siblings. On January 17, 1981, Georgina's home was the object of a new police incursion. It was a group of police that were specialized in the fight of subversives. And they got the victim, who was barefoot, and grabbed her by the hair in front of their siblings, the Inchis, and they started to search her home, and then they grabbed the neighbors, and from the home, the only woman who was taken as a prisoner was separated from her neighbors and then taken to a room where there was no one else gathered. At night, on the same day, on December 17, 1981, sent 7 members into Georgina. They started to interrogate her, accusing her of a terrorist. Even though she said no, then she started screaming and asked for help, and then they gagged her, and her cries for help couldn't be heard. Then they took her to Ayacucho the next day. The victim was without communication, wanted to know of her family. It was a cousin of hers that found her after 2 weeks. They found her in very bad condition, bloodied, and she was mistreated. And so the police during that period preserved Georgina to confess. They obliged her to have arms and took photographs. And then in Huamango, they said that they found arms in her home. And Georgina, the state didn't give her a lawyer. A lawyer in 1981 said that the victim was a minor, and said to have her to get a legal medical exam of being a victim of sexual violence. And she denounced the sexual violence of which she was a victim. Then, after what happened in February, and Ayacucho civil authorities, she had her first medical exam. She didn't send signs of external damage. In January 17, 1981, they saw that she was 18 years old, and they presented at about 3, and then Georgina, that there was sexual rape. States that there were contradiction there. However, the presentation reiterates that Georgina was 16 when the events happened. In January of 1981, the state, the observations of the state is based on an expert witness of someone from the police, with, in essence, they presented contradictions that come from doctors of the state. Afterwards, and in May 13, 1981, the judge determined that Georgina was raped by these policemen when she was detained, and she was seen to be now pregnant, and as well, and determining her that she was a minor, the judge decided, ordered her liberation in May of 1981, after she was detained for several months in a prison for those of legal age. The sexual rape and the pregnant caused her severe psychological damage. During the period she was in jail, she suffered emotionally and psychologically for having been raped. She declared she also thought about suicide. Then out of the jail, she didn't receive any support from human rights groups. Then she needed to get medical attention because the opposite policeman was the one responsible for her pregnancy. Then she was attended until October 19th, Rebecca was born. Then Georgina wanted to give her daughter in adoption. In that stage of her life, in the stage of life of Rebecca, it was very important the role of her family. On the one hand, to give all the support that Georgina needed in her pregnancy, and on the other hand, to have a family member that supported her without reproach. The first internal process.
Como resultado de la denuncia que realizó el abogado de Georgina Gamboa, en 1981 se inició una investigación por la violación sexual. En esta investigación, Georgina rindió su declaración hasta en 3 ocasiones, sin ningún acompañamiento o asistencia por parte del Estado. Esta investigación además adoleció de distintos defectos. A un año de iniciarse, el fiscal solicitó su archivo, señalando que no se había probado quién o quiénes fueron los responsables, pese a que por el poco tiempo transcurrido todavía era materialmente posible individualizar a presuntos responsables. El 11 de enero de 1982 se ordenó el archivo provisional de esta primera investigación, y un año después, el 21 de febrero de 1983, la Fiscalía recién advertía que no se habían ahondado en las investigaciones, que no se había abierto instrucción contra el jefe de línea de Caso, quien era responsable de Georgina durante su detención, y sobre todo, sin que se hubieran incluido como presuntos responsables a los miembros de la Guardia Civil y demás integrantes de la línea de Caso. Este pronunciamiento ya adolecía de estereotipos de género, pues señalaba que Georgina Gamboa fue violentada a consecuencia de, y citamos, los bajos e irracionales instintos de malos funcionarios. El 16 de marzo de 1983, el juez instructor amplió la investigación por un plazo de 20 días. Posteriormente, el 5 de mayo del mismo año, se amplió nuevamente, esta vez por 30 días, plazos que no tomaban en cuenta la complejidad de los hechos denunciados. Apenas el 16 de mayo de 1985, se emitía un auto de enjuiciamiento, señalando que había mérito para pasar a juicio oral contra quienes fueron individualizados como presuntos responsables. Sin embargo, el 10 de diciembre del mismo año, si bien reconocía que Georgina Gamboa fue víctima de violación sexual, señalaba que no existían medios probatorios para una sentencia condenatoria. El fundamento para esta absolución se fundamentó en que la víctima, durante sus declaraciones, incurrió en contradicciones respecto al número de responsables, ignorándose que, por la situación traumática, sobre todo en los casos de violación sexual colectiva, las víctimas pueden caer en tales contradicciones. Esto lo ha reconocido el propio perito ofrecido por el Estado durante su peritaje. Más allá de ello, la sentencia adolece de estereotipos que demuestran una falta de imparcialidad al señalar que las verificaciones a los miembros policiales, como la denuncia de violación sexual y maltratos físicos realizado por la señora Georgina, no sería sino una reacción, citamos, de la violencia contra el orden, del delito contra la ley, para tratar de desvirtuar la validez de numerosas pruebas de responsabilidad halladas, insinuándose que ella denunció la violación sexual solo para librarse de los cargos que habían en su contra. Georgina, que en ese tiempo ya vivía en Lima, tomó conocimiento de la sentencia absolutoria posterior. En medio del conflicto armado interno y ahora con una menor a su cargo, Georgina ya no quiso saber del caso. Tenía temor de volver a Ayacucho y no quería recordarlo. Sobre todo, no quería continuar presionando acciones contra los efectivos policiales a sabiendas de todo lo que su familia había pasado. Luego de la creación de la Comisión de la Verdad y Reconciliación, Georgina Gamboa brindó su testimonio en una audiencia pública el 8 de abril de 2002. Para ella, esta oportunidad supuso una nueva esperanza, de que tal vez, denunciando nuevamente, por fin encontraría justicia. Esto implicó que su hija conociera por primera vez la verdad de la que había buscado sentada al lado de su madre,
She was sitting next to her mother, and she heard with the rest of the audience everything Georgina went through. This affected her profoundly, and in that story, she understood the relationship with her mother during childhood and adolescence. Facing the truth was not easy, but Georgina understood that it was not only for her, but also for her daughter. After her testimony, Georgina and her daughter needed psychological treatment to improve their relationship because the state never gave her any assistance. This was only possible thanks to the support of organizations from civil society who supported Georgina for several years. However, Georgina did not get the justice she was hoping for, and the state did not start any type of investigation and could not revise the ruling before previous ruling, because this only happens in convictions and something that didn't happen. So, with the help of the Court of Inter-American Human Rights, she was able to open her case with a new complaint. A new investigation was opened where Georgina participated. It was mentioned that she was not present in all of the
Sin perjuicio de ello, los
hearings.
estándares
However,
interamericanos
she
señalan
was
que la
there.
investigación de la violencia sexual no puede quedar supeditada a la carga procesal de la víctima, sino que constituye una obligación autónoma e intransferible del Estado. En efecto, correspondía a los órganos competentes dirigir la investigación y encauzarla de acuerdo con las estrategias o líneas de investigación determinadas por ellos para el esclarecimiento del hecho. En todo caso, la investigación debe ser impulsada de oficio, sin que las víctimas o sus familiares tengan la carga de asumir tal
so that the victims don't have
La
this
señora
burden.
Georgina no solo participó
Ms. Georgina
diligentemente,
did not
sino que
only
sus
participate
representantes
actively, but
solicitaron la
her
realización de
representatives
diligencias que
asked
consideraron
for
pertinentes,
diligences
conducentes e idóneas para el esclarecimiento de la
for
verdad.
the
El
clarification
17 de
of
febrero
the
del
truth.
2006,
In
Comiset solicitó por
February
primera vez la
2006,
realización de la prueba de ADN. Por
she was
primera vez,
asked for
pues durante el
DNA
transcurso del mismo
testing,
año lo reiteró
and through
hasta
that
3
year,
veces.
she
El 24
asked
de mayo,
again 3
el
times
12 de
more.
julio, el 2
May
de octubre,
27,
sin que
July
la
the 12th,
Fiscalía se pronunciara
and one more time,
aceptando o
without the
denegando el pedido.
prosecutor's office
La
said
aparición de
it gave
una
her
prueba
any answer
científica
or
concluyente
being
como esta
against of it.
constituía motivo suficiente para reabrir una
This
investigación
was
o realizar diligencias
important
complementarias.
to
La jurisprudencia de esta
start new
honorable corte
investigations.
exige
So
que
this
las
court
autoridades valoren diligentemente las pruebas científicas y
needs
no
to
desestimen hechos relevantes sin motivación razonable.
understand
En el
the
presente
important
caso,
facts
no
of this
puede
case.
responsabilizarse a la señora Georgina ni
Ms.
a sus
Georgina cannot be
representantes
responsible
por
or
la
her
falta de
representatives
pruebas
for the
o
lack
por
of
la supuesta
proofs
inactividad procesal.
or
La obligación de impulsar el caso,
inactivity in the
incorporar nuevas
process
pruebas
to
científicas
gather
y
more
garantizar un
evidence,
proceso
physical
diligente
evidence,
recaía en
and
el
to have
Estado. Después de 2006,
due
Comiset
diligence
continuó solicitando a la
part of
Fiscalía
the
la realización
state.
del examen de ADN.
She
Sin
continued
embargo,
asking for the
apenas en
DNA
2022,
test. However, only in
17 años
2022,
después de la
17 years
interposición de la denuncia
after
y 16
the
años
complaint
después del primer
and
pedido de
17
realización
years
del
after
ADN,
the
la
first
Fiscalía
request for
recién
DNA,
desestimó el pedido,
the prosecutor's
alegando que
office
existía una sentencia de
denied
carácter constitucional, archivando
this,
también la investigación,
also
en
archiving
virtud del
the
principio
investigation.
levis in. Ante lo sucedido, no se puede justificar en absoluto la
What
excesiva
happened cannot be
demora de una
justified.
decisión de archivo de
The
investigación
time that it took
en base a un principio que bien pudo
based
señalarse
on a
oportunamente,
principle
y
that
no
could
tantos
have
años después.
been
La omisión
solved
de utilizar pruebas en el archivo definitivo
earlier.
de la investigación evidencia una falta
This
de
is
debida
evidence
diligencia,
of the lack
reforzada,
of due diligence
incompatible con los estándares fundamentales,
that is not
que exigen
compatible
al
with
Estado no
international
solo
standards
abstenerse de
that
probar hechos, sino también garantizar efectivamente el
should
acceso a
guarantee
ellos.
access to
La
justice.
obligación de investigar no se cumple con meros trámites formales,
Investigation
sino ni puede depender de la inactividad
cannot
procesal
depend
de
on
la víctima o sus familiares
the
o de la aportación privada de
process
pruebas.
not being carried
Por
out.
ejemplo, el Estado
It is
debe
a
decidirse
duty
con
of
celeridad,
the state
orientado a
to be
esclarecer
serious
los hechos
in
que
order
están
to
señalados en las
clarify
investigaciones. Sin
all the
perjuicio de
facts,
ello,
everything that
en lo que
happened.
respecta al levis in,
However,
aun cuando es un derecho humano
even
reconocido
though
en el artículo 8.4 de la
it is a
Convención,
human right that
no
is
es un derecho
recognized in
absoluto
Article
y
8,
no resulta aplicable cuando la actuación del
this is
tribunal
not
que
applicable.
conoció el caso de medidas provisionales. Esta ley ya cuenta con 2 reglamentos preaprobados que reiteran la imposición de sanciones a los representantes o a las organizaciones que utilicen la cooperación internacional para la defensa jurídica o acciones judiciales o administrativas contra el Estado, lo que podría dejar en indefensión a las víctimas. Han pasado más de 40 años desde que Georgina Gamboa espera justicia para ella y para su hija. Durante las acciones judiciales ella estuvo comprometida y participó activamente. Hasta la fecha, ella no ha perdido la esperanza. Cada declaración implica revivir los hechos y los años de impunidad, sobre todo teniendo en cuenta que el Estado ha reconocido tácitamente su responsabilidad al inscribirla en el Registro Único de Víctimas. La falta de acceso en sí misma constituye una vulneración a la integridad personal por los daños y padecimientos a su esfera psíquica y moral. A diferencia de su madre, esta es la primera vez que Rebeca declara respecto a los padecimientos. A través de su testimonio se ha podido evidenciar el daño transgeneracional que hoy la convierte en víctima. Asimismo, su valiente testimonio el día de hoy también ha servido para poner de relieve una afectación que frecuentemente es invisibilizada, la afectación de la familia.
Con respecto a las medidas de reparación, esta representación se remite sobre todo al escrito de solicitudes, argumentos y pruebas presentados oportunamente a este honorable tribunal. No obstante, nos parece importante resaltar el fundamento de la obligación de reparar en un contexto del conflicto armado interno que implica violencia y violación sexual en esmero de los derechos de población indígena, mujer, niña, quechua hablante y extrema pobreza. Además, resaltamos que el Estado no puede invocar disposiciones de derecho interno para modificar o incumplir las obligaciones de reparación, que está sujeta en todos los aspectos, esto es, alcance, naturaleza, modalidades y determinación de los beneficiarios al derecho internacional. Dado el carácter de las violaciones cometidas en el presente caso, que hacen imposible la plena restitución de los derechos lesionados, el Estado debe adoptar las medidas compensatorias necesarias para garantizar la debida indemnización moral y material de las víctimas y sus familiares, así como medidas de satisfacción de los derechos violados y las garantías de no repetición. Las reparaciones, así como el término lo indica, consisten en las medidas que tienden a hacer desaparecer los efectos de las violaciones cometidas o al menos buscar una restitución a todo lo sufrido.
Habiendo quedado demostrada la responsabilidad del Estado a través de lo expuesto y sin perjuicio de que esta representación se expresará en sus alegatos finales escritos respecto a las excepciones preliminares interpuestas por el Estado, solicitamos respetuosamente a esta honorable Corte que declare que el Estado violó en perjuicio de la señora Georgina Gamboa García los derechos a la libertad personal y derechos del niño, contenidos en los artículos 17 y 19 de la Convención Americana, el derecho a la integridad personal, protegido en el artículo 5 del mismo instrumento, el derecho a la protección a la honra y la dignidad, contenido en el artículo 11 del mismo instrumento, y los derechos a las garantías judiciales y la protección judicial, reconocidos en los artículos 8 y 25. Asimismo, también la vulneración de los artículos 1, 6 y 8 de la Convención Interamericana para prevenir y sancionar la tortura y el artículo 7 de la Convención Belém do Pará. Asimismo, respecto de su hija, Rebeca Ruth Gamboa García, solicitamos que se declare que el Estado peruano vulneró su derecho a la integridad personal por los padecimientos ocasionados por las circunstancias de su concepción. Finalmente, que se declare también que el Estado peruano violó respecto de Máximo Gamboa Castillo y Dolores García Gutiérrez, padres de Georgina Gamboa, el día de hoy fallecidos, así como Clementina, Heráclides, Nemesio, Delfín, Piquiedi, Luis Fidel, Rosa y Mayra Gamboa García, así como Efraín Gamboa García, la vulneración de su derecho a la integridad personal, el artículo 5 de la Convención Americana, debido a los padecimientos causados por el temor generado a raíz de los hechos, la separación de su núcleo familiar y la falta de justicia por todo lo que sufrieron como familia. Con base a las referidas vulneraciones, solicitamos a la Honorable Corte que ordene al Estado implementar las reparaciones solicitadas. La señora Georgina Gamboa y la señora Rebeca el día de hoy vinieron a compartir sus testimonios con la esperanza de brindar un cierre al ciclo de dolor que ha teñido la historia de su familia y simbólicamente también la historia de tantos otros casos como los de ellas, no denunciados. Ellas han demostrado fortaleza y han sabido sobreponerse por su cuenta, pero nunca han perdido la esperanza. Honorables magistrados, esta es la oportunidad de demostrarle que estos 40 años de lucha no han sido en vano y que la justicia, aunque haya tardado, todavía llega. Muchas gracias.
Muchas gracias. Seguidamente le corresponde el uso de la palabra a la representación del Estado para que hagan sus alegatos. Adelante.
Con su venia, señora. ¿Se escucha? Ya. Señora Nancy Hernández López, presidenta de la Corte Interamericana de Derechos Humanos, señores jueces y juezas de la Corte, señores representantes de la Comisión Interamericana, señora representante y señores representantes de la presunta víctima, muy buenas tardes. Siguiente diapositiva, por favor. El día de hoy la representación del Estado peruano está conformada por Domingo Rojas, abogado de la Procuraduría Pública Especializada Supranacional y agente alterna del caso, y quien les habla, Carlos Yaja, Procurador Público Adjunto Especializado Supranacional y agente titular. A continuación, y sin perjuicio de lo que ya hemos señalado en nuestro escrito de contestación de fecha 12 de febrero del año 2024, vamos a exponer argumentos fácticos y jurídicos que permitirán a este tribunal determinar la inexistencia de la responsabilidad internacional del Estado peruano. Para tal efecto, la exposición constará de 3 partes. Primero, relacionado a los cuestionamientos procesales. Aquí vamos a demostrar que el sometimiento del caso adolece de vicios, que este tribunal carece de competencia ratio temporis y ratio materiae respecto de determinados hechos y que la inclusión, hace un momento señalada, de presuntos familiares como presuntas víctimas contraviene el reglamento de la Corte. En relación a los aspectos fácticos y jurídicos, vamos a poner en relieve las inconsistencias en las declaraciones, así como las deficiencias generales en la valoración probatoria y en la construcción de la narrativa de los hechos, lo que impidió acreditar responsabilidades penales individuales conforme a los estándares probatorios exigidos. Finalmente, haremos referencia a las recomendaciones y a las reparaciones. Se controvertirá aquellas propuestas de reparación que carecen de sustento jurídico y resultan desproporcionadas, subrayando que el Estado ha cumplido con su deber de investigar de manera diligente en 2 procesos distintos y que además se ha otorgado medidas de reparación en sede interna. Dicho esto, le cedo el uso de la palabra a Domingo Rojas, quien se abocará a la primera parte de la exposición.
Señores jueces y juezas, en el presente caso, el Estado peruano planteó 3 cuestionamientos procesales. En primer lugar, solicitó un control de legalidad por parte de este tribunal sobre las actuaciones de la Comisión Interamericana, al haberse identificado a lo largo del trámite una errónea posición asumida que finalmente se plasmó en el escrito de sometimiento del caso ante la Corte. Un segundo cuestionamiento procesal está referido a la falta de competencia de este tribunal para conocer la causa a partir del reconocimiento estatal de la jurisdicción contenciosa. En primer lugar, sobre la Convención Interamericana para Prevenir y Sancionar la Tortura, así como de la Convención de Belén do Pará. Y en segundo lugar, respecto de la Convención Americana sobre Derechos Humanos. Cambio de diapositiva, muy bien. Ahí. Respecto del primer extremo, el Estado peruano advierte la ausencia de competencia ratione temporis, toda vez que las primeras 2 convenciones que hemos mencionado entraron en vigor a partir del 28 de abril de 1991 y del 4 de julio de 1996. Los hechos, como se ha señalado, son del año 81. Es decir, la vigencia de ambas convenciones es posterior a la fecha de los hechos del presente caso. Asimismo, teniendo en cuenta la jurisprudencia interamericana, recordamos que los hechos como tortura o violación sexual carecen de un carácter continuado y en base a todo ello consideramos que esta Corte carece de competencia. Señores jueces y juezas, la Corte, en el caso del Campo Dot versus México, ha señalado que la tortura se ejecuta o se consuma en un mismo acto y su ejecución no se extiende en el tiempo, lo que le otorga la categoría de delito de ejecución instantánea. Asimismo, las secuelas de tortura, alegadas por los representantes de la presunta víctima, no es suficiente para señalar que se trate de un delito continuado. Respecto al segundo extremo, corresponde recordar una vez más que los hechos sucedieron el 17 de enero del año 81, fecha previa al reconocimiento de la competencia contenciosa de este tribunal por parte del Perú. Ello a partir de la vigencia de la Convención Interamericana, Convención Americana. En tal sentido, a la luz del principio de retroactividad dispuesto en el artículo 28 de la Convención de Viena sobre el derecho de los tratados, y según la posición asumida por este mismo tribunal en los casos del Campo Doc versus México y Blake versus Guatemala, esta Corte solo tiene competencia para conocer los hechos ocurridos. Solamente tiene competencia para conocer los hechos ocurridos en los estados tras el reconocimiento de su capacidad contenciosa. Este criterio también ha sido establecido por esta Corte en el caso J versus Perú, al señalar que el acto de violencia sexual sufrido por la señora J en el año 1995 no le era aplicable ni la Convención Interamericana para prevenir y sancionar la tortura, ni la Convención de Belén do Pará. Por tanto, se configura la excepción de falta de competencia de este tribunal. El tercer cuestionamiento procesal, como ya se ha indicado, se refiere a la indebida inclusión de otros familiares como presuntas víctimas, en desatención a lo señalado en el artículo 35.2 del reglamento de esta Corte, que establece que solo cuando se justifique la imposibilidad de identificar a presuntas víctimas por tratarse de casos de violaciones masivas o colectivas, que no ocurre en este caso, el tribunal decidirá en su oportunidad si las considera víctimas o no. En esta línea, nótese que ha sido a través del escrito de fecha 7 de diciembre del año 2018 que los representantes señalaron y reconocieron únicamente como víctimas del caso a la señora Georgina y a su hija Rebeca. Sin embargo, luego del informe de admisibilidad emitido en junio del año 2022, los representantes pretendieron incorporar a sus padres y a 8 hermanos más, evidenciándose con ello una confusión sobre la identificación de las presuntas víctimas del caso en la etapa de implementación de recomendaciones. Sobre el particular, el Estado considera que ninguna de las 10 personas agregadas luego formaron parte de la petición inicial, tampoco suscribieron comunicaciones posteriores, ni participaron en el impulso de la causa a nivel interno. En tal sentido, consideramos y rechazamos esta inclusión indebida que pretende ampliar el número de personas considerándolas como presuntas víctimas. Expresados estos cuestionamientos procesales que requieren atención, a continuación se harán observaciones de fondo al marco fáctico planteado por la Comisión. Sobre los hechos, ya se han pronunciado ampliamente la Comisión y los representantes de las presuntas víctimas, por lo que no resulta necesario reiterar la descripción detallada de los sucesos. No obstante, corresponde enfatizar en que dicho relato, al interior de estos relatos se han encontrado contradicciones sustanciales, particularmente en las fechas y circunstancias de la detención, así como en el contenido de las declaraciones de la señora Georgina Gamboa y en los resultados de las pericias médicas practicadas en el año 81. Tales inconsistencias, que no han sido resaltadas por la Comisión ni los representantes, resultan determinantes para evaluar la solidez del caso y la imposibilidad de acreditar responsabilidades penales individuales conforme a los estándares probatorios exigidos por la Convención Americana. A partir de lo planteado por la Comisión Interamericana, el Estado evidenciará algunas contradicciones que han sido advertidas. Sobre la fecha de detención de la presunta víctima, resaltamos que a través de la petición inicial se indicó la existencia de 2 actos, uno el 25 y otro el 29 de diciembre del año 80. Respecto de la presunta detención del 25 de diciembre, los peticionarios indicaron que la presunta víctima fue detenida en su domicilio y posteriormente llevada a la comisaría de Vilcas Huamán, lugar en el que habría permanecido cerca de un mes. Sin embargo, en el escrito de observaciones sobre el fondo, indicaron que luego de la detención en su domicilio el 29 de diciembre, fue llevada a la comisaría de Vilcas Huamán, donde solo permaneció una noche. Contradicciones que también se han vuelto a indicar en el interior de esta audiencia. Es relevante recordar que en la petición inicial se indicó que hubo una segunda detención del 29 de diciembre. Sin embargo, la Comisión finalmente dio por probado que durante los operativos policiales la presunta víctima fue detenida recién el 17.
So you see that in this the preceding evidence in the court case, this took place on January 17, 1981. On the medical exams that the alleged victim had, there are different things that happen in these exams, chronologically and having to do with the sexual abuse. It's in the February 11th, 1981, there is an expert witness in addition, the second opinion in January 16, 1981, that's where there were these contradictions. And May 22nd, 1981, and the experts that participated in the medical exams they determined the chronological age, which was 17 years old. Then Georgina, and this event, this fact, was it so that she would put at the disposition of the jurisdictional body, which was for families.
Having said this, we will start with the final arguments regarding Articles 5 and 11. Peruvian state will not take into consideration Articles 1, 6, and Articles. It is known that during a torture case, it is important to analyze the elements, the intentionality of the agents suffering, physical or mental. So, after the debate of the experts, there is a psychological investigation. However, they recommended a psychiatric investigation, but the victim did not do it. Under these conditions, the Peruvian state, her rights were not violated. The Commission and representatives However, we will now show you how the state worked, and the alleged victim was motivated by Article 1 from 17 December 1980. And January 14, 1981, and she was detained on the 17th. At that time, she was found with explosives and firearms that supposed this is a flagrant situation, and this is shows harm for others, and is cause for detention, immediate detention. And there is no legal in the framework of what was established in regarding Article 2 from the Convention. The victim knew the motives of her detention, which was the homicide of the owner of the farm. And at the time, she was found with explosive and firearms. Regarding Article 7, after her detention on January 17, they informed of her detention so that there is some type of control. And Article 2.20G from 1969 establishing that in the term of 24 hours, we need to take into consideration the distance and the time that passed corresponds to the logistics and accessibility regarding the rural environment. Under those considerations, there is no violation of Article 7. Regarding Article 19, as we have mentioned, such circumstance was communicated only on February 17, 1981, without proof, truthful proof. So there was an investigation to establish her chronological age. There was an investigation carried out to know her real age, and this was determined on May 22nd. And at that day, the process was stopped, and her liberty was ordered. So I give the floor to my colleague now. Regarding Article 8 and 25, according to what the Commission said, the state is responsible of her detention and access to justice and truth. Even we have 34 years have passed. No responsibility has been determined. However, as I will expose, they lack any support. And at that time, when she manifested, she was
que fueron finalmente objeto de un debate pericial, a partir de cuyas conclusiones el órgano jurisdiccional emitió una resolución el 28 de mayo en la que dispuso el corte de la secuela de este proceso y del proceso respecto a Georgina Gamboa. Cabe señalar que la investigación fue inicialmente archivada el 6 de
investigation was archived in January 6,
el 21 de abril del año 83,
but then opened
una acusación sustancial por el delito de violación sexual contra 11 personas. El 5 de junio del año 85,
on charges of sexual violence for 11 people, and these hearings were carried out later on.
Los medios de prueba de cargo y de descargo, así como los alegatos e informes presentados por las partes, el órgano jurisdiccional dictó sentencia absolutoria el 10 de diciembre del año 85. En dicha decisión se concluyó por un lado que al momento de la detención de la presunta víctima se encontraron armas de fuego, casquillo y un petardo de dinamita. Por otro lado, en relación a los actos de violación sexual,
regarding sexual violence, there were contradictions in the arguments of the testimony of the alleged victim.
requerido para desvirtuar la presunción de inocencia. En el segundo proceso penal,
in the second trial, there was a new complaint in 2005 to investigate torture in detained people and freedom of sexual liberty. And during the second trial, as during the second investigation, different proceedings were taking place, and psychological investigation to gather the most amount of proofs. In April 2022, they decided not to continue with the preparatory investigation. With the following reasons: regarding sexual violence, crime,
lo que configura la aplicación de la garantía del deber civil antes señalado, regulado en la Constitución peruana y también por la Convención. Sobre el delito de lesiones, uso de violencia y prácticas de tortura en detenidos, el órgano fiscal precisó que la sola declaración de la presunta víctima, quien afirmó haber sido secuestrada y torturada para incriminar a su padre, no resultaba suficiente como medio probatorio al no haberse logrado corroborar dicha versión con otros elementos de convicción. Sobre el delito de secuestro, se invocó el artículo 223 del Código Penal, que sancionaba a quien, cito textual, sin derecho privare a otro de su libertad personal. Sin embargo, en este caso, la imputación recayó en miembros de la Guardia Civil y de la policía, quienes en ejercicio de sus funciones de
Police, in the exercise of their functions, they consider them authors of alleged homicide. The deprivation of liberty was now without foundation. The moment that the knowledge is made of the events that occurred, ladies and gentlemen, judges, though there's a federal report on the Commission of Truth supports the expert witness, the commissions on truth are not determining, does not substitute a national judicial proceeding. And there's a report on the commissions of truth. They're instruments that are complementary on the reasonable term of the investigation. This was initially seen as 1. Regarding the complexity of the matter, this case, seeing the evidences, it's very complex because these were done between 1980 and 1981. In other words, the time that had transcurred between the events that happened 24 years afterwards, the investigations. In 2025, it's important to see the legal representation of Mrs. Gamboa change in several opportunities. It could have changed this strategy for litigation, and through the proceeding through time, there were changes in the prosecutors. This was because there's an area of difficult coverage. A scheduled psychiatric evaluation was not carried out. Regarding the behavior of judicial authorities, regarding this, the Peruvian state emphasizes from the final sentence in 1985 and 1986, and the prosecutor's statement in 2006. We must point out in the first proceeding between 1981 and 1986, there were about 28 testimonies. There were exams taken to the victim, and in 2005 there were 7 manifestations, 2 medical exams, and more than 20 requests to different entities, and more than 30 notifications. This was the basis for the prosecutor on reparations. The Peruvian state sees several different areas of reparations. If you have any questions, Howard, we can look at the conclusions of these interventions. The Peruvian state states that it is that submitting of this case has serious errors, and including family members as alleged victims is against the rules of procedure of this court. Second, the lack of coherence in the narrative of the facts creates limitations for the judicial work, and it cannot have the degree of certainty required by criminal proceedings. And also, the Peruvian state has accredited in its writ answering writ, giving concrete reparations such as inscription in the registry of victims, economic reparation to Mrs. Gamboa of 10,000 soles, and access to programs of health and housing as well. So this, honorable judges, non-existing foundation to declare the responsibility of the Peruvian state, we will now finish our presentation. Thank you very much. Thank you very much. To use the reply of replica, the representatives of the victims. Aquí está breve. I will use, they have the floor, then I'll give the floor to Christian Wiley. First, regarding there's a lack of competence to knowing the cause, it's important to point out that the representation has not requested at any point that this exceeds the competency of the court. There are events that happen after, such as the detention, when When beyond January 21st, 1981, the lack of compliance and the forced pregnancy as a result of the sexual violence. The court has competency to recognize these events. It also has competency to recognize, spoke on the vulnerability of Article 7 of Belén do Pará and 128 of the American Commission to Prevent Torture. This refers to when after these instruments, the state did not do its due diligence in investigation, and it also has, the court has its competency regarding regarding the incorporation of the family members. Their incorporation has to do with independent violations of the commission. It's an exam of form that the Honorable Court can do. And regarding the testimonies of the victim, it's important to say that with a factual framework regarding regarding the testimonies of Georgina in the second proceeding, a date was never determined so that she could appear again for a new testimony. That cannot be determined as a lack of procedural activities, particularly from her. It's time to pronounce ourselves on the criminal responsibility of Georgina Gamboa as an obstacle. We can remember there's a case regarding Peru. It's clear that the criminal responsibility of the woman so this documented by the state cannot be considered in the measure in which Georgina Gamboa is excluded from this investigation. On the other hand, regarding the second prosecuting investigation, it's important to see from this beginning, the DNA testing was affirmed. Also, expert witness opinions that were also approved. It's important to point out that the fundamental basis to know the truth of the events that occurred, and also with the truth from Rebecca to know the truth of her birth, was not even evaluated and much less carried out. What's curious is this was requested from 2006, and only in 2022, 17 years afterwards, the only communication from the public ministry came at that time. Thank you very much.
This does not reflect what happened in Peru. clarify some issues. First, Georgina Gamboa was not detained illegally. There was a legal investigation because firearms were found in her possession. Something that the expert witness did not mention is that at the time of her detention, there was no ID that would identify her as a minor. Only after this debate, they established that she was a minor, which it is affirming that there is no justice so far is not true. The processes took place in 81 and 82, and there was an absolutory sentence. A judgment of dismissal. But in this case has been studied for 18 years. And regarding DNA, in 2005, the DNA did not correspond because the crime of sexual violence had already happened, and which was dismissed in the 80s. So reopen these sobre el principio de ley civil, como ya lo han señalado los representantes, esto no constituye un derecho absoluto y estamos de acuerdo. Su excepción requiere condiciones estrictas, ciertamente, fraude procesal, falta de independencia o investigaciones o investigaciones manifiestamente defectuosas. En el presente caso y en el expediente, in this case, there is no complaint regarding this type of fraud in the first process because there was no legal impartiality. There was an investigation, and this was resolved at the time. Lo que básicamente señalamos como un acto que no hemos tenido conocimiento de manera previa. Por lo cual igual también señalamos cuáles son las razones por las cuales no deben ser tomados. Dentro del tiempo nuevamente señalado, concluimos con nuestra presentación. Muchas gracias, señora representante del Estado. Seguidamente le corresponde el uso de la palabra a la representación de la Comisión Interamericana.
Madam President, Georgina Gamboa has been seeking justice for 44 years. We have heard how as a 17-year-old indigenous Thank you. She was detained without due process not once but twice by police in the Thank you. Yes, she was detained without due process not once but twice by police in the context of the state's response to the armed conflict. The second time, she was held in police premises, beaten and raped by a group of police. She remained in blood-stained clothes, she told us today, for 2 weeks in detention that would last 5 more months. It is undisputed that Georgina was raped in police precincts by police. Undisputed. In Indeed, on January 6, 1983, the senior prosecutor of Ayacucho said that the rape had been proven. Yet, none of those who detained and tortured her, all identifiable, were held responsible, not in criminal proceedings or even in employment-related administrative disciplinary proceedings. And she received no psychological, social, or financial support from the state at the time. So she's come today, and what has she said? I need justice. Honorable Court, the Commission will make its observations in three parts. Firstly, the preliminary observations raised by the state. Secondly, the merits of the case. And thirdly, reparation measures. Regarding the preliminary objections, the Commission reiterates the written observations submitted to this court on April 18, 2024. But given the state's submissions, the Commission will present two aspects. The state alleges the lack of jurisdiction due to time for all acts prior to the date on which Peru ratified the contentious jurisdiction of the court. The Commission clarifies that it asks the court to consider the actions and the omissions of the state that occurred after January 21st, 1981. Among them are violations of the American Convention, violations of the Inter-American Convention to Prevent and Punish Torture, and the Convention of Belém do Pará, derived from the second illegal and arbitrary detention of Georgina Gamboa, which, although it began to be carried out on January 17, 1981, continued to be committed until June 1981. The court is also competent to hear the actions of the state authorities in the context of the conduct of the investigations and the impact on the personal integrity of the victim's next of kin, since they are independent or autonomous acts. On the timeliness and the requirement of exhaustion of domestic remedies, the state argues that the first criminal proceeding concluded with the ratification of the acquittal of the accused on May 8, 1986, and that the petition was filed on September 21st, 2007, having exceeded the conventional period of 6 months. In addition, the state indicates that because of the new complaint filed by Mrs. Gamboa in November 2005, it was ordered that the investigation be opened or reopened, it was still in progress when the petition was presented to the Commission. In our admissibility report, number 61 of 2014, the Commission analyzed the application of an exception to the exhaustion of domestic remedies and the resulting reasonableness of the time frame for filing the petition in accordance with Article 32.2 of the Rules of Procedure. The Commission considered that the state had the opportunity to investigate and resolve the alleged violations, taking into account that the events occurred in 1981 and the situation of impunity that existed at the time and persists to this very day. Secondly, the requirement of exhaustion of domestic remedies is assessed at the time of its decision on admissibility, not when the petition is filed. The Commission applied the exception under Article 46.2c of the American Convention due to the state's initial investigation ending in acquittals without due diligence. Secondly, the 2005 reopening of the case and the fact that 8 years later it remained in the preliminary stage, demonstrating the utter ineffectiveness of domestic remedies. Therefore, the Commission asked the court to reject the state's objections, these preliminary objections. On the merits, the Commission emphasizes the state's position in the proceedings before the court has been to indicate that the case is not framed within a context of gender violence and armed conflict, and that the acts against Georgina Gamboa were the subject of investigation. The Commission rejects this position. The violations perpetrated against Ms. Gamboa is part of a widespread sexual violence against women and girls, especially indigenous and peasant women, during the Peruvian armed conflict. This has been documented by the United Nations Special Rapporteur Against Torture, by the Office of the Ombudsman in Peru itself, and the Truth and Reconciliation Commission. The state itself acknowledged that Ms. Gamboa and her daughter are registered in the Unified Registry of Victims created for persons who were affected by the internal armed conflict. The Commission will now present on the following. 1, the detention of the victim from the date of ratification of the court's contentious jurisdiction, and secondly, the failure to properly investigate and punish the violations committed. On the detention of the victim and the conditions in which she was held until her release, the state has alleged that Georgina Gamboa was detained on January 17, 1981, in accordance with the law. We just heard that. And that it was based on criteria of proportionality. In addition, it argues that the age of the victim was unknown until February 1981, and that she was released after studies confirmed her minority in May of that year. The Commission recalls that the court has established the essential elements for deprivation of liberty not to be arbitrary or illegal in accordance with the provisions of Article 7 of the American Convention, and these were not met in this present case. First, the arrest of Georgina on January 17, 1981 was not the result of in flagrant delicto and did not have a court order. The Commission notes that although the court has had jurisdiction since January 21, 1981, on that date the victim was still illegally detained in violation of Article 7.2 of the American Convention. Second, on the right to personal liberty and to judicial protection, there is no information that shows that the arrest charges were explained to the victim, much less that it was done in Quechua, her mother tongue. On this point, the Commission notes that by the date of the court's contentious jurisdiction began, January 21, 1981, the situation had not been remedied, and thus the illegality of her detention continued. Third, although the duty to record any arrests was not suspended by any state of emergency, the police authorities issued an official letter referring to the arrest of the victim and other persons 9 days later, without clearly indicating its causes. I want to repeat that. Without clearly indicating its causes, those responsible, the time and the circumstances. Fourth, there is no evidence that Georgina Gamboa was brought before a competent judge without delay, as provided for in Article 7.5 of the American Convention. Her first appearance before the examining court in Humanga was on February 3rd, 1981, 16 days after arrest. This is even more serious when one considers her condition of vulnerability as an indigenous girl who had been gang raped in custody. Fourth, the state failed to comply with its duty to provide special protection, since the victim's case was referred to a juvenile court only in May 1981, despite the requests being made by her defense in February of that year. And I believe the burden of proof here lies on the state if it wishes to disprove minority status. The deprivation of liberty of Georgina Gamboa was arbitrarily prolonged until June 1981 due to the lack of competent judicial control, and despite the fact that her status as a child and her pregnancy by then were well known to all concerned. Consequently, the Commission asked the court to declare the state responsible for the violation of the rights to humane treatment, personal liberty, and special protection of children established in Articles 5, 7, and 19 of the American Convention. The second point concerns the justice component. In reiterated jurisprudence on this matter, this court has established, on matters such as this, the court has established that in cases of violence against women, the state's obligation to investigate effectively has additional scope, which includes, among other aspects, that the processes be carried out with a gender and intersectional perspective, and that measures be taken to avoid re-victimization. The investigation into the rape and torture suffered by Georgina Gamboa was closed on 3 occasions, and to date the facts have not been clarified, nor have the people responsible been punished. The Commission highlights the multiple shortcomings and irregularities over more than 4 decades since this event. So 1, the first investigation provisionally closed by the public prosecutor in 1982, arguing that although the crime of rape was duly proven, it is not proven who the perpetrators were. This decision does not contain a list of evidence or facts, which is incompatible with the duty to state reasons, since it prevents understanding the reasons for archiving such a serious case of sexual violence perpetrated by police officers in a police precinct. Secondly, although an accusation was later made against at least 12 defendants for the facts, they were acquitted because the judicial authorities privileged and considered their account over the consistent version that the victim had offered from the beginning of the process. In addition, the acquittal decision did not consider any other evidence. 3, it does not appear from the file that the judicial authorities had ordered the conduct of interviews, complete and detailed medical and psychological examinations by suitably and trained personnel on the victim. Fourth, the only medical report available concerns the victim's age and reveals serious shortcomings. All examiners were men with no intention of offering a woman present despite reported sexual violence. Exams were likely not conducted in the victim's native language or with an interpreter, and clear signs of abuse were not documented as evidence of torture or rape. 5, as established in our experts, Dr. De Corletto's report, there's also no evidence that the medical or judicial personnel clearly explained to the victim the situation and the particularities of her pregnancy, thereby contributing to her emotional and mental affectation. 6, the judicial reasoning behind the acquittal reflects sociocultural stereotypes about the Quechua communities and presumes their involvement in armed conflict, and there is a quote to that effect in the judgment, which I won't read because of time. 7, the second investigation initiated in 2005 was provisionally closed in 2011 and definitively so in 2022, arguing that the identity of the 7 responsible for the rape had not been established. This was due to the failure to carry out basic procedures such as a genetic test of Mrs. Gamboa's daughter. We've heard a lot about the request for DNA, which would confirm at least the responsibility of one of the state agents. All of these aspects have prevented access to justice for the victim and her family, and we ask the court to declare the state responsible for the violations of a right to fair trial, judicial protection, as well as humane treatment. The Commission asserts that the state is responsible for the violation of the rights contained in Articles 5, 7, 8, 11, 19, and 25 of the American Convention, but also violation of their obligations established in Articles 1, 6, and 8 of the Inter-American Convention to Prevent and Punish Torture, as well as Article 7 of the Bell and Paro Convention to the detriment of Ms. Gamboa. Finally, the Commission reiterates the reparation measures formulated in its merit report, including the measures of compensation and health care for Ms. Gamboa, her daughter, and her family members. On guarantees of non-repetition, the Commission emphasizes the need for the state to adopt protocols both preventative and responsive. The state has a positive duty to prevent sexual violence of women and girls in detention from the moment of arrest. The state must also ensure that the care and examination of victims of sexual violence in detention meets inter-American standards with an intercultural accommodation for girls and adolescents. The upcoming judgment from the court, this honorable court, is crucial for truth and justice for Mrs. Gamboa and her family, and could set a precedent to prevent re-victimization and support other women affected by sexual violence in the context of detention during the Peruvian armed conflict. I thank the honorable court for this opportunity.
Muchas gracias a la Comisión Interamericana. Seguidamente pregunto a mis colegas si quieren intervenir. Juez Diego Moreno Rodríguez.
Ahora sí. Muchas gracias, Presidenta. Efectivamente, voy a formular unas pocas preguntas si me tienen la paciencia. En primer lugar, me gustaría formular una pregunta a la representante de las presuntas víctimas. ¿Ustedes coinciden con lo que manifiesta la
Do you agree with what the Commission is mentioning on the exact date when the second detainment of Ms. Georgina happened?
Sí, señor magistrado, esto
Yes,
fue también informado por
Mr.
los
Judge.
representantes, incluso en la respuesta a las excepciones preliminares, los representantes nos estamos
The representatives,
fáctico
we
procedimiento
are
de comisión.
abiding by the factual framework.
En segundo lugar, una pregunta.
Second, I have a question to the state representatives.
Yo entiendo que se cuestiona,
I understand that regarding reparation, the life project, could you please elaborate on the reasons for your opposition? What we mentioned is that in the Peruvian state, we will also talk about this in our written argument. There is a reparation policy, comprehensive reparation policy. Not only economical, but also the education and health and others. These policies are being implemented continuously, not the ones... Sorry, Doctor, but I have here a quote that the court has stopped applying this. Does this appear in your arguments? Are you not questioning this? No, but in the final arguments we can clarify this. Another question for you. You recognize that there are exceptions, and I refer to the DNA testing, and after we've heard the testimonies that we've heard today, this will be a way of identifying the responsibles for what happened, but also to determine the paternity of one of the alleged victims. I don't know if you have any comments on this. These are powerful principles, strong principles, and I don't understand why you're against this, if this is a reparation method.
In effect, we take the position of the public ministry in our answer that the concrete action to have a DNA test would be to not recognizing a final judgment from 1981. It's within our constitutional framework and the articles. We are of the position, we respect the other positions, that to ask a DNA testing to review facts that have been already resolved from 1981, 1982, and 1983, and it would affect the legal security. But that is the position of the Peruvian state. Another question for the agents of the state. I understand that at some point you point out that emotional and psychological aspects were not proven to the family members of the declarant. What would the evidence standards that you would require for this to happen? Today we heard from the victims, the alleged victims, at 4 in the morning, the police entered her home when she was 17 years old in front of her siblings. They removed her from the home. What would be the evidence that you would need to accredit a violation of Article 5 of the Inter-American Commission? Thank you, Judge. Mr. Judge, regarding your question, our relation to the standards that the Peruvian state considered when this right is violated, we consider that the process of research of the events to be able to determine the adequate legal framework, and we need to have a major element to consider regarding the affectation that has been shown. Just to complement what my colleague is stating, principles are the criteria that we said that need to be configured. It's clear that the evidence needs to be coherent and sufficient. Those requirements that we talked about, that the medical requirements didn't prove elements that have to do with torture. I'm talking of the documents that are in the file, not the testimony of the victim. So there's no corroboration also of the testimonies of the representative in the first phase of this case. There are changes of dates. There's some confusion here. Within that framework, we can't have sufficient elements to determine a criminal responsibility. Thank you very much for your question, for your answer, excuse me. I would like to refer in English because we have in the commission Dr. Roberta Clark.
Just like some clearance and you already stated this and also repeating this, that this is extremely important. What is the Commission's position regarding the allegation by the state that some of the victims are not expressly included in your final report? Do you have a comment on that?
Thank you very much for giving us the opportunity to speak to what we call the universe of victims. The Commission first notes that the victim, her daughter, and her parents are identified in the merit report, which is the basis of the case before the court today, and it's based on the information available from the parties. However, if we look at paragraph 33 of the merit report, the report refers to. Yeah, I'm seeing here. I just want to refer the court to the paragraph. The report refers to the existence of at least 7 siblings of Mrs. Gamboa, and in fact, she did already speak about the number of siblings that she has who were present at the time of the events, but who were not fully identified due to lack of information at the time. So given the nature of the facts raised and the direct affectations, the court could consider including such relatives of the victims when you approach your judgment. The question of the grandchildren, which has come up in the expert evidence, is also of an important feature of this case and a new feature of this case. Grandchildren, of course, were not in the universe of victims referred to in the merit report, but there's definitely very much a direct impact upon the grandchildren in relation to what happened to their grandmother, and the court heard evidence of that today. Ms. Gamboa had to leave her community. She had to flee her community for fear, for the stigma. She went to Lima. She was isolated from her own family, where she had her child, and then her child, who we heard from today, Rebecca, then also had 2 children, but they have been severed from their traditional community. So we have before the court here evidence from, the best evidence really, evidence from Mrs. Gamboa and her daughter about the impact of the violations on them individually, but also on the family members, including family members that came subsequently.
Thank you, Commissioner Clark. Thank you very much for your question. Tengo una última pregunta nuevamente para los agentes del Estado. Y esta pregunta la voy a formular con el mayor de los respetos y con el reconocimiento del formidable trabajo y la solvencia profesional que caracteriza a la defensa pública.
And regarding the Peruvian state. Now, in this case, specifically, the presumed victims, about their women, indigenous communities, they do not read or write. They have the support of a woman that they have a perspective in this case, in this special case. Yes, within the supranational, we have a multidisciplinary team, not only lawyers, but they're lawyers with different specialties. We've done analyses of this. If you want to see this in the questioning, we were very careful with the questions that we did in the contest. In the context, and the answer is yes. Yes, thank you very much. I don't have any more questions. Thank you very much. Thank you, Judge Moreno. Now, Judge Perez Goldberg, do you have any questions? Yes, good afternoon. I'd like to do some questions to the presentation of the state. Like if you can specifically state, if you can tell who is in charge of identifying a person who was charged of a crime, because it says here that Mrs. Georgina, at that moment, she was 17-year-old. She was charged with homicide, and the lack of identification of her was because her defense of being a minor was not provided to the judicial authorities. So if you can clarify to us who is in charge of the identification, if someone in the police who looks to look of the identification registries, how was that process carried out? Thank you, Judge. That will allow us to. Yes, that a very precise answer, please. We've heard a lot of explanations. Yes, the detention of Mrs. Georgina Gamboa was done with the beginning of an investigation of homicide. A traditional order was given on December 24th, and the National Police was ordered to do the investigations and to detain all the responsible parties. Then, after the elaboration of the report of the state, so they could come to the police station where we see that the daughter of the murdered person identified Mrs. Gamboa as the author, the person who committed the homicide. That's why February 23rd amplifies the investigation. And on 17, she was detained. This was all is in the jurisdictional body, and the detention was done through the National Police as well as the reports. But this was done after January 17th. So from January 17th, so she was taken where? Can you answer that, please? Her detention, the state does not know that she was a minor until her lawyer communicated that. That's what I wanted to ask you. When a person implied in a crime is detained, in that moment, how was there certainty of the identification? Because in the registry, there are official documents, or persons only identified what the person would say or their lawyer would say. Yes, that's correct. We're talking about parameters from 1981 in Peru. There were no national identity documents, so we can presume if a person was detained who had arms in their house, that person needed to be investigated. That's why we have the expert debate, and then we see that there was no formal document that says she was a minor, and the defense lawyer carried that out. How can you see that the fact that at that time, I can review that, we had the civil code was in effect that established being a minor up to 21 years old. And that is to say that the civil code was not used as an identification mechanism. No, in the case of the investigation, the criminal code was in effect of 1924. The civil code provides to have conditions of restricted responsibility that when we use in the criminal code. Those persons who are of legal age up to 21 years, the crime could be lowered if a crime was committed. It's restricted responsibility. Now, I'm not referring to the civil code that establishes a vulnerability. In 1984, the law was modified, and then from minors 18 years old. Before it was up to 21 years old. So was the code, the criminal code applied? Yes, Judge. The civil code of 1984, it's Article 42, that pointed out that the age was lower. On that question, we'll extend our final written arguments. Now another question. When this detention is carried out in January 17th, where was Georgina taken? The commission has taken it as the truth that on January 17th the detention is carried out of Georgina in her home. And afterwards she was put to the disposition for being transferred to the city of Ayacucho. On what day was she detained in Ayacucho? From January 17th, where the detention was made, until January 26th, where she's put to the disposition of the jurisdictional body. And from that moment, and then we asked the prison of the, excuse me, I'm having trouble with the audio. Where did they deprive her of her liberty in Ayacucho? What date? On January 26th, but according to what's pointed out in what was in the file, in January 19th, she was in the city of Ayacucho. From January 19th, from January 17th, she was deprived of her liberty in Ayacucho. Where? At the police station, yes. And after, since she had an order of detention, she was taken to a prison. At what point is she moved afterwards? That in the final written arguments, we will give detail on that. Because we need to request information from the prisons. But she was in a prison for adults because her being a minor had not been determined. How long did she stay in a prison for adults? Up till May 10th. And when was her condition as a minor established. It was clarified on May 22nd, 1981, with an expert debate. And then there's, on May 18th, there's an imposition where she was declared to be free. His freedom is produced. Because she was a minor, she was a victim. Yes, it cuts the penal process against a person of legal age. This disposes for the case to go to a court for minors. What happened with that? There was no advancement made there. How did it finish? From information from the organizational body? Not the organizational body for those of legal age. They established a series of measures that they could take. No, the investigation was continued, but there was no measure of deprivation of liberty or detention there. Thank you. The representatives of the victims, if you state, give your answer in regard to these questions. Thank you, Honorable Judge. Mrs. Georgina gave in her testimony the information where she was detained. It is true that from January 19th, she was detained in Huamanca, Gacucho. She referred to the fact that she was detained in the Comombin. Is a police area, and then after that she was transferred to a prison for adults. We know that she was in a prison for adults until May 22nd, 1981, after approximately 4 to 5 months. To complement a judge, it's important to say that the expert exams were carried out in February, and only in May her status as a minor was established, and that's where we put the cutoff point of the proceeding. Representative of the state, if you have something regarding that information. Were the expert investigations done in February? Yes, they were done on February 11th and February 16th. The expert were reviewed that case regarding to determining their status as minors. Each one determined their report, the police and the hospital. This happened with more than 35 persons, and there was also a debate ordered, and each person was liberated, and the liberation that's produced first, and after the second expert testimony was done, and then we see the expert testimony debate, and then the hospitals are in those cases were far from the place, but the jurisdictional body ordered it, and her status as a minor was determined, and she was liberated. Thank you very much. Judge Goldberg. Judge Gomez, thank you, Madam President. I have some Questions for the state, starting with Deputy Agent Rojas. When you talk about jurisdiction and the application of the Convention of Belén no Pará and the Convention Against Torture for penalizing torture, did you say that not apply to this case? Is that the argument of the state? It did not apply this because of a complaint of torture. In this case, Article 8 of the Convention Against Torture says that the state's parties guarantee all persons that denounce that they were subjected to torture in their jurisdiction that be examined impartially. Basically, so that doesn't apply to this case? Okay. The state alleges that the Article 7 of the Belém do Pará Convention does not apply also. Another question. Does the state alleges that unless the victims are identified in an initial petition, they cannot be considered as victims by the Inter-American Commission? Is that what the state says? The content of the rules of procedure of the court, that in cases that's the rules of procedure of the Inter-American Court. The question is different. It was in the report of admissibility to see if the state argues who presents the first petition, and unless the list of victims is perfect or exact and totally understood, then the commission cannot do reference to other persons of the merit report. Yes, and we recognize that the merit report of victims of the case, what we argue is during the initial petition, those persons were not considered as being affected. So we could not require information how they were affected. I understand. You said that the family members had to do independent reports of Georgina. Yes, Judge. What we pointed out is that the Commission has the duty to identify the alleged victims. What we're saying is that, conform to the Article 35, that we all know was the moment to identify. It does not come within the cases that the court should handle. I said that the person needed to be identified in a detailed manner in the visibility report. Perhaps I heard it wrong. Afterwards, I listened with great attention to the questions that were made regarding the determination of the age of Georgina at the moment of detention. We talked about an order, detention order. That detention order is not in the file of the court, and so I would like to understand if there was really a detention order. In the Inter-American case, the first registry of detention was January 16th, 1981. The first time that there's a a writ about the detention for us to understand the detention, to have a copy of the detention order beyond the first detention that was referenced here, requesting that the police detain all the possible persons who were responsible of the murder of a person. So in order to understand the legality of the detention, it would be good to have the detention order where Georgina's name can be found, because it's not in the file right now, I tell you. Thank you.
About the debate, we had very good, important questions regarding the determination of the age of the detained person. The state alleged that there was a process being carried out about the age of the person that took 4 months, and there is another one, an expert report that maybe the person was younger than 18 years old. What we don't understand is why the person is detained 5 months, and there is a possibility, clear possibility, that the person might be a minor. She was 5 months detained.
En efecto, lo que hemos señalado, de repente, señora jueza, no he entendido bien la pregunta, entiendo que es una opinión. Usted me ha dicho, ¿cómo es posible que pueda estar 5 meses detenido?
Did you say, no, how she was 5 months detained? No, the question is that there was a debate, an expert debate in May, but there was an expert testimony that said that she was 17. But actually she was 16. It says approximately 17. Okay, so then the state said that one person under their custody probably was younger than 18. However, she was detained at a center for adults. And what is not clear from the argument from the state, once they identified that she was younger than 18, she was freed. But you also said that she was responsible for a crime. So that doesn't match. If this is not the object of the case, of this case, but it has to do with the legality. Was she formally accused for a crime? Why then she was detained for 5 months? Madam Judge, once the process is finished, the state does not follow a process as an adult, but she was sent to minors because she was a minor, because the code of minors established this. So there was an investigation where there was no responsibility with other people that were also investigated, but the responsibility was not determined. Okay, but there are several questions on how the detention was carried out, that she was dragged by the force and with violence. So there are many questions. Because you talk about the legality of the detention, I don't have the papers, But there are also arguments here that how this detention was made, and also the situation of the siblings, the younger siblings, Georgina siblings at that time. Another question. Which I think was quite worrying. The state mentions this is a question that I have regarding the burden of proof. It was said that the investigation based on the facts have failed because the testimony of the victim was inconsistent. She said she was attacked by 3, by 5, by 7 people. So it was also alleged that the testimony wasn't enough for the determination that there was torture. Now, the question for you is, we are talking about a person who was under the absolute control of the state. The state controlled the visits she received. She received the visit of a cousin at some time that brought her medicine and clothes because she was bleeding 2 weeks later. And the government has said that this is not what happened. So how do you think the burden of proof happens? Because the arguments of the state was based on the testimony that it is inconsistent. But we have a case where the case has total control over who was in contact with the victim. I will start with the first question, where the main contradictions. I will talk about that question first, about the contradictions on the testimony. First, there were some contradictions in the number of participants of aggressors, also contradictions in the place and circumstances of the aggression. Different spaces were described. First, maybe it could have been a dungeon, at the police station, at her home. We will talk in detail about this in the written argument. Also, the testimony talks about at the moment, after a few days. In the reports, there were no marks, physical marks, so there is no degree of certainty. We're not saying that there was no rape, but for the determination, we need high amount of proofs, and that did not happen. Regarding the burden of proof, we have mentioned are based on the documents on the file. We have emphasized that these cannot replace an investigation. We're not talking about the report, the merits report. I'm talking about the burden of proof. What we're saying is that the state puts the burden on a person that is a minor, that doesn't speak Spanish, and also, even though it was on a detention center or the police station, the state does not negate that they have a full control of the situation, and the effect, which is the consequence, are deletions and the pregnancy, are part of the file. So how can it be that there are inconsistencies, but on the other hand, we have this effect? Yes, the concrete situation is that during the process, during the 1980s and 2005, everything was analyzed. Just so you take into consideration this, we are talking about a person that is under the control of the state while the situation is happening. So how is this interpreted? And lastly, the state mentioned that this is a complex case. When you talk about the timing, because it happened in 1981, that the state mentioned I want a clarification on which accused part. We're talking about the legal.
La seguridad jurídica no del Estado, sino de los que fueron acusados justamente por el tema de la... Le explico. No era una sola persona la que fue imputada como un acto de violación. Fueron en un primer momento 3, 5,
At the beginning, when the testimony mentioned that it was 3, 5, 7, up to 11, and I just want to clarify that these, we wanted to analyze parameters from 2005 and 1980. So we understand that the DNA test will be against what was already decided at that date. That's the foundation of the legal certainty. If there is no DNA test, we will never know who is the responsible. Those are my questions. But thank you. Thank you, prosecutor, for answering the questions patiently. Thank you, Madam Judge. Are there further questions? Yes, Madam Judge, thank you. I have a few questions. Something that caught my attention was that Miss Georgina gave birth at the police hospital. I want to know why, the reason, why, due to the background. Thank you, Mr. Judge. As we have mentioned through this process, the sexual violence has been confirmed, and there was presupposition that it was carried out by agents from the civil guard. However, the perpetrators were not able to be individualized. We understood that the context and the responsibility was from the police. And when she is freed and she goes to Lima, when she was 5 months of pregnancy, the diligence are carried out in the Ministry of the Interior, and the Ministry of the Interior gives the pass to Georgina to be taken care of at the police hospital of Peru due to this institutional responsibility. And regarding the conditions of the care, were they correct or proper? That was throughout a year, right? Yes, we need to highlight that that was for a period of time. The pregnancy and a posterior treatment, it was for a determined period, and there was no more medical treatment for Georgina or Rebecca after that. I have a question. Regarding a reparation measure, which is related to DNA. You mentioned that the DNA results would give information that would identify at least one of the responsibles. So you asked the court for the DNA test to be carried out to Ms. Rebecca.
Partamos un poco muy brevemente del contexto del proceso judicial realizado en la década de los 80. La sentencia del 85 básicamente...
The sentence from 1985 says that in 1985 we didn't have a judge for taking a sample for the DNA test. Afterwards, in the 21st century, we had the technology to do that, to have a new test. A new test is conclusive, and it doesn't show vulnerability to what was judged, because this test was not given in the previous case. Beyond the criminal process, and to individualize those responsible. We remember that Georgina is a victim in this case, and also we recognize the right for Rebecca to request the truth in the framework. Do you look? Yes, look in the framework of the investigation. Within the framework of the investigation, we have identified numbers, as we just said to the state, that there's a high number of persons who would be suspected of sexual violence. It's not a high number, it's about 11 persons, so it's not a whole platoon or anything like that. To do the DNA tests were suspects of having carried out the sexual violence. It implies the identification to be able to identify the perpetrators. I'd like to ask the state what difference of the prenatal difference, where it would seem in the request of the representation, no, here's a path where the request of paternity would work. Can you explain how this defense would work? Judge, the state said in their answer is that given the possibility of to use the DNA test to see the direct link in one who was investigated for the events that happened to Mrs. Gamboa, to see that the event of rape was admitted in 1985, which is absolved because of lack of evidence. When we see to credit the rape, so the person from the public ministry what that person did understand that this event, the rape, could not be newly investigated. And seeing that this test would be linked to the fact of to charge the rape crime, this, as you can see, in the second pronouncement in 2018, the request was resolved, and they determined that because they determined that there exists a possibility to know the paternity, there's a way that you could paternity affiliation with all those responsible parties, because the paternity affiliation is in force. I don't know if that was understood, but that's what's in the writ of the answering writ of the state. Clarify that yes, I understood your explanation. It's not the moment to review that specifically right now. I'd like to know as a representative, and to also see the merits report, to look for the context, and within that context, not only the context of safety of the conflict regarding a modus operandi in these types of cases, and more if it's about indigenous peoples or persons. This came out in the expert report or testimony they were heard this morning. Is that concept to your criteria? Is there thank you, Judge. Yes. If the events were the events happen of Georgina Gamboa is the beginning of the eternal conflict, 1980-1981, as pointed out to the Commission on the Truth and the sentence of the Inter-American Court for Mrs. Espinosa. There was a problem with the sexual rape and sexual violence within the framework of this conflict. In 1981, there was no operations plan, and this systematicity could not be proven. In the case of Georgina, there are no changes of sexual violence with the Truth Commission. That's we are pointed that even though it was at the beginning, it can be proved within the context with Georgina. This all has a beginning and Georgina. This could be the beginning of sexual violence because of the terrorism. Thank you very much for your response. I would like to give the greeting to Roberta Clark, the Commissioner. It's our pleasure to have you here in this hearing. Yes. What degree? You asked about the expert witness today, if you can give me consideration the degree of systemization in the case of Peru when you talk about sexual violence. My question specifically, if you can derive from the events that happened in this case, compared as the representative of the truth report, the existence of a systemization from representatives of the state in a situation like this one.
Señor juez, para complementar.
Is to complement to the response to the commissioner, the framework we identified the report having to do with torture, the report from 1992, 1993, and I quote, the existence of the frequent practice of sexual abuse from the police and military, and also torture referred to the practice of sexual abuse, and frequent was done to peasant women within the framework of the armed conflict. That's was compiled in the decade in the 90s, and it also saw the information at the beginning of the 1980s where the armed conflict had begun.
Hola.
Yes.
El informe de
Microphone not working.
Aló. Perdón. Una vez más. El informe de la Defensoría del Pueblo
Report of the Public Prosecutor's Office also refers to the information in national legal cases of complaints of sexual abuses at the beginning of the 1980s, where the armed conflict began in Peru. And the Commission also quotes reports on themes and countries, and also against indigenous women, where we have sustained information from other organs, including the United Nations. Thank you, Judge. Question for us is very easy to respond. Well, you can't talk about systemization in an event that happened in 1981. To demonstrate systemization, the state has to have a generalized practice. And when there's Ayacucho terrorist activities, the response within the contents of an emergency response, the start can be proven, but the beginning, also the DBR final report, other documents that have to do with the Inter-American Commission. We will say that those documents do not cannot be used evidence as for this purpose. In conclusion, for the Peruvian state in 1980s, systemization cannot be configured because generalized practice had not been proven up to that point. Yes, thank you. A burden of proof had not been shown at that point. I would request if you can describe the state has had concrete actions to ensure indigenous women access to justice and also access to justice to women who are victims of sexual violence and are indigenous. From 1981 to up to this date, there have been changes in your legislation. Can you indicate that to us, or to indicate that there's no new information that can be provided? Thank you very much to everyone for the answers. I don't have any more questions. This question has no more questions. For adjourning this public hearing, I would like to remind the parties and the Inter-American Commission that in accordance with the provisions of the 16th operative paragraph of the resolution of the Presidency of the Court of August 13 this year, the representation of the alleged victims, the State and the Inter-American Commission have an unextendable term up to October 24th, 25th to submit their final written arguments and final written observation, respectively, in relation to the preliminary objections and eventual merits reparation and extensions of the case. I would like to thank Mrs. Clark for her presence and also the presence of the alleged victims and to this Peruvian state. And the meeting is now adjourned. Thank you very much.